Welcome to Legal Dilemmas, where you will find clear, concise legal advice. Today's episode is about applying for a non-molestation order. And Savina, can you elaborate on what a non-molestation order is?
Certainly I can, Brenda. Well, so far you've had hopefully some good understanding of what constitutes domestic violence. We've given you an insight into what legal protection is available to you under different legislation. And now what we're trying to do is go through, different areas. A non-molestation order injunction is the one that, as we said in our last video, is the one that most practitioners recommend to clients who come to see them. So in terms of what it is, well, funnily enough, there's no statutory definition of what constitutes molestation. But essentially, it's said that it's wider than violence, and it includes serious pestering and harassment, and it has to affect the health, safety or well-being of the other individual, the one who is obviously being subjected to domestic violence.
So, is an assault eligible to apply for if somebody's the victim of an assault? Can you, because you talked about harassment and pestering, but if you're assaulted or beaten, would that be for the police or would it be for a non-molestation order?
Well, if it's an assault, well, the police can pursue it for you on the basis of criminal proceedings, because it depends on the nature and type of the assault, as I've said in a previous video. So it could be a battery, it could be a common assault, it could be an actual bodily harm, or it could be grievous bodily harm. But it is eligible for you to also pursue it through civil remedies, through the family courts, through a non-molestation order injunction, absolutely. But in order to be able to apply for it, Brenda, you need to have what is called locus standi under the law, and that essentially means you need to be an associated person to the person against whom you are applying for a non-molestation order.
Okay, so who can actually apply then?
So to be an associated person, it's quite a wide definition under the law. So it could be a current or former spouse or civil partner. It could be a cohabitant, and that's sort of widely defined. It could be a current or previous fiancé. It could be a relative, a family member. It could be parties to the same family proceedings, or it could be parties that live in the same household, or parties who've been in an intimate relationship, Brenda. But that relationship does need to be of a significant duration.
Okay, so can you quickly summarise how you would apply for it and if you actually have to go to court? Because a lot of people are scared of attending court.
Well, you would need to apply through the courts, unfortunately. There's no way around that. Your solicitor would need to complete the relevant application form for you. It's an FL 401 form for you. You need to pay a fee if you're not exempt from paying a fee. And there are fee exemptions that are available to you if you are on benefit or in receipt of a particular kind of benefit. But that's for a different day. And then you would need to file any documentary evidence and a statement as part of your application. You need to give reasons for why you require such an order. The court will then list the matter for a hearing. You can attend yourself if you're not in a position to afford legal representation, or if you can, which we would highly recommend, benefiting from legal representation, attend with your lawyer, and the court will hear your application and make a decision on what should happen. But obviously the court's not going to make a final order until notice has been given to the other party, who is the respondent within these proceedings, because you would be the applicant.
Okay, so will the other party be there when you go to court?
Not on the first hearing. Well, I suppose it depends. I mean, if there's sufficient notice given, and the sealed copies are sent to you and you can serve those on the other party, then yes, they would be given notice and they would attend on that time. But, you know, practicalities of whether the court sends out notices on time, and it doesn't mean that the other party will attend. They may decide that, you know what, we're happy for an order to be enforced and we're not going to attend court at all.
Okay, thank you. Hopefully that explains what a non-molestation order is and how you can apply for one. Please access the support services available if you are a victim of domestic abuse. Hopefully you found this video content useful. Please like, subscribe and share, and have your notifications on to hear more great legal content.